أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم نحمده ونصلي على رسوله الكريم. Nowadays we are discussing making of a will, Wasiyah. But along with that, we are discussing other aspects also, which are all related to the major concept of Tarkah. So we are discussing inheritance in general terms, Tarkah. We are also discussing will, and we are discussing it as a compact concept or a package as a legacy, that one should make the will as a legacy. One should leave the inheritance for his inheritors as a legacy. It should have some purpose, it should have some meaning, and it should serve the purpose which, in fact, the Quran wants. Just to recapitulate what we discussed last time, that so far as law is concerned in the West, particularly in the West, so far as the law is concerned, there it is not only the law of the will, but it is also law of inheritance, and it is not only the law of inheritance, but it is also the law of intestacy, when there is no will. When somebody has not made a will, then also all these matters have to be tackled under the law. And when there is a will, then that also may have to be proved. Last time we had said that a will has to be proved. And what is the process called in this respect? That is probate. So when the person dies, it is not the person in the family who has a vested interest in the will or in the portion or in the inheritance, but it is the neutral court which decides the matter. Even if there is an executor appointed by the by the deceased person who has died, even then the probate is decided. The probate takes place and the will is proved when it requires to be proved. And when there is no will, then again there is a law. It has to be decided under the law. This was just to bring up to date what we had discussed last time. Now, we are in the 21st century. It is 1500 years, more than 1500 years, that these laws were given to us. Sharia is in the Quran. Islamic law, Islamic jurisprudence, or Islamic concepts, they are given in the Quran. Sharia is in the Quran. But it becomes law when a positive law is made by the law-making authority. For example, there is a punishment of whipping for the person who drinks. It is there in the Quran. There is a punishment for adultery. It is there in the Quran. This is Sharia. But there is no Sharia law unless the positive law is made by the law-making authority. And in 21st century, it is basically, usually, in majority of the countries, it is the parliament. But unfortunately, we are still depending on the fatwa by the contradictory people who make contradictions. Not only they make contradictions within other institutions or other persons, but even when you analyze their fatwa over a period of time, there are internal contradictions within their fatwa. So there is no Sharia law. There is Sharia in the Quran, but there is no Sharia law. Because when we say law, law means positive law. And positive law means the law made by the authority, by the sovereign authority. That law has the sanction of the sovereign. It has the sanction of the state. It has the enforcement power, and the court enforces it. The administration supports it. The executive supports it to implement it. But the fatwa have no sovereign sanction. They are not supported by the courts. They are not supported by the administration. and people are left in the limbo. They are confused what to do. That is why I had selected to discuss the law on the subject from America mostly and from some other Western countries, and also because of the fact that I'm addressing the people mostly, they are living in America. So therefore, they have to know the law of the land, and the law of the land has to be respected. And it is basically necessary to understand that what is the difference if at different points between these two laws, or if there is no difference, then how it has to be implemented. For example, in Britain, the English word, first time, word probate we have discussed. They brought this concept and they applied it in 15th century, in the middle of the 15th century. Today is 21st century, which means about 6 centuries back. They were so enlightened that they made the positive law, and they made laws that no single person who has vested interest in the inheritance or in the will and who is strong in the family, he should implement it. They gave it the protection of law, and they developed the concept of probate in the 15th century. We are in 21st century. We have to at least think today so that we can take some step tomorrow. But still, I don't think we are so much enlightened to take steps in this direction. In some countries, in Muslim countries, yes, there is some law, but it is not being implemented. You consider any country to which you belong. The inheritance is divided by the person who is the strongest in the family and who has the vested interest in the inheritance and in the will. And this is injustice. Injustice to the weak, to the women and to the children, to the orphans particularly, to the old people, to the parents. In the will, the executor is appointed by the testator, by the person who is making a wasiyah. He makes the appointment of the executor. The testator makes the appointment of the executor, that who will execute the will. The court does not execute the will. Court proves the will, that yes, this is the will. To this extent, it is the will. And such person is authorized as an executor to implement this will. And that court extends the authority, the legal authority, so that the executor becomes a legal person. He becomes a legal executor to implement it, because it has a sovereign sanction. It has support of the state. It's not like fatwa, which has no sovereign sanction. But Wasiyah is supported by the state. In all the civilized countries, in the West, for example, in America. And here one has to understand that the executor acts on behalf of the state. We have to understand the difference. The executor does not act on behalf of the deceased person. He does not act on his behalf generally in all matters. He is not holding any attorney, power of attorney. It is the concept is that he is acting on behalf of the estate, on behalf of the portion of the property which has been subjected to him. He is representative of that property. He is acting for that property, and that is called estate. So he is acting on behalf of the estate of the will maker, testator, estate of the will maker, not just straight away that he's acting on behalf of the testator. No, he's not acting on behalf of the testator, legally speaking. Because the testator may have many other things to do. The deceased person may have many other things to do with the property. He's not doing everything. He's only to the extent of the estate given in the will. He is representing that only. Executor is a legal person. He is a representative of the deceased person's estate. What is estate? Estate is the portion of the property which is subject to the will, not all property. That portion which is subject to the will of the testator. Appointment of executor becomes effective only and only after the death of the testator. Even if there is a will, a person has made a will 10 years back, his children cannot demand him, cannot force him to distribute the property according to the will. They cannot demand it. It will become available only, and the executor will be responsible only after the death of that testator. But in some cases in counseling, the parents complain that although I have made a will, but my children are forcing me, they are torturing me. Particularly the mother says this, my husband has died. Now I'm surviving. And I have also made a will, but my children are now forcing me to distribute it before my death. What should I do? What the law says, what the Sharia says about it. They cannot force her to distribute it. The entire property which she has, and even the portion of the will for which she has made a will for that property, portion of that property, they cannot force it. They cannot ask it because the situation might change at the time of death. The role of executor is to resolve testator's estate. If there are problems in the implementation of the will, it is his role to resolve those issues involved. And the court is there to support, to legally resolve those issues and implement the will according to the law. So the basic role here of the executor becomes, if somebody asks you that I'm making a will, and may I mention your name as the executor? Think it carefully. Think about it carefully. It is a big responsibility. But you should never say no. Truthfully, faithfully, honestly, you have to support, you have to accept the role, you have to accept the responsibility, because even in matters of writing, even in matters of becoming a witness, the Quran says don't refuse it. As Allah has taught you, and in this case, as the court has directed you, legally, truthfully, and honestly, act for that estate on behalf of that estate of that testator. And to distribute, one is to resolve the estate, all issues. Number two becomes very important, to distribute the estate to the beneficiaries, not to oneself, not to other persons, to the beneficiaries. And here it means the beneficiaries in the will. And the will means which has been established legally. And the executor means the legal person, the representative, which has been allowed by the court. And to those who are entitled, I have mentioned this word separately. One is the beneficiary, who are the shareholders, who are the sharers, for example, and then those who are entitled. Besides Waldain, besides Akraba, the Qurba are also mentioned. They also become eligible. The debtors, the persons for whom the deceased person was holding any liability, they are also entitled. They have Haqqal Malum. It is Maruf. These words are used by the Quran. They are entitled. So this has to be determined. Executor steps into the shoes of the deceased for that estate. For estate is that portion of the property which is subject to will, and have similar rights and powers to wind up personal affairs of the deceased to the extent of the will, not others. He is not responsible for any other thing. For the portion of the property which is called estate of the deceased. This may include continuing filing lawsuits. So that is why I said that when somebody asks you to become the executor, think it carefully, but don't refuse as an honest person. If you can do, but if you can't do this, you have any handicap, then you can refuse, of course. But normally, without any concrete reason, it should not be refused because tomorrow that person's family may face the same problem. Continuing or filing lawsuits that deceased was entitled to bring to the extent of that portion of the property, which is called estate. Making claims for wrongful death. This is very important to understand. There are sometimes cases in the court that the person made a will at night and in the morning he was found dead. Was it a wrongful death? Was it because it was the consequence of the will? And so many other things. There can be many other things. So if the executor brings a case, the court will not say that you are not related to him. You are not his uncle, you are not his father, you are not his son, so you cannot bring the case. But since he is executor in the will, he can bring the case. That I sense some foul play, he can bring a case of wrongful death. The court has resolved it. This is just an example. There can be different examples. Paying off creditors, paying off all the debts, even the debts of the wife, they have to be paid. Selling or disposing of assets not particularly included in the will. This is very important to understand. There are sometimes such things which are related to the assets of the will that unless those are done or those formalities are completed or they are disposed of, this cannot be done. But since the role of the executor is to step in the shoes of the deceased and to play the role to resolve the testator's assets, he has also the responsibility to do this. But all these things are to be authorized by the court during the process of probate. When the will is proved, the executor is proved, and he is authorized to act according to the will, and so on. After testator dies, a person who has made a will, he dies, executor named in the will can decline even after that or renounce the position and quickly notify the probate. For example, if executor was mentioned in the will and person dies, next day or after some time or on that day, for example, something happens, there's an accident. The executor is now not able to do anything, not perform the role, or there are some other handicaps which are created, then there is a provision that he can decline or he can refuse, he can renounce, but he has to notify it immediately to the court, to the heirs also, so that legal arrangements are made for the next executor. Then the court appoints it. Then who will be the executor? When a person dies without will, intestate, we have mentioned that there are laws, then legal personal representative, that is executor, is known as administrator. If the person dies without a will, the court will appoint the executor. But in that case, he is usually called administrator. So whenever the word administrator appears, it will mean that he was not appointed by the testator, but he has been appointed otherwise. This is commonly the closest relative. Usually, court has also limited power. Court does not pick up a person of their choice, not to appoint some of their relatives, somebody from the court. There can be situations, but not usually. There is a list, and in that there are priorities. And those priorities are relations. And in Islamic jurisprudence also, there are priorities for the relations. Which relation has the priority in inheritance, and similarly, which relation has the priority to become the executor. Although that person can renounce their right to be administrator, in which case the right moves to the next closest person. For example, court says that we are appointing the eldest uncle, the brother of the father, but he refuses. He has some handicap. Then they will appoint the next uncle or the next maternal uncle or something like that. So then there is a list of priorities, priority relations. This often happens when parents or grandparents are first in line to become the administrators. The parents or grandparents have the preference, but there is some problem they cannot. They don't want to become, but they renounce their right on the grounds that they are elderly, they are incapacitated, they do not possess knowledge of state law, or they feel that someone else is better suited to that task. The court can then go to the next category, to the next priority, to the next priority. Appointment of administrator follows codified list. As I mentioned, that the list is codified. It is given in the law. The court cannot import from outside. It has to go according to the preferences and priorities given in the law, according to the law. Although relatives of the deceased usually have priority over all others, some other person may act as administrator if there is some cognizable reason or relationship to the estate. For example, the persons who are mentioned in the will, who are going to inherit that portion, who are to be distributed from that portion of the property which is mentioned in the will, who are to be distributed that estate, there is an objection that the administrator which the court has appointed or is proposing to appoint, they have an objection to that. They have some fears about it. They think that he will not do justice. Then they can request the court. They can make an application that they will not be satisfied with this administrator. Some other administrator from the list may be picked up, and they can indicate their preference. There are time factors also in filing and objecting to claims against the state. It is not open forever. But for example, somebody comes after 20 years. No. Law of estoppel will also apply. It will operate against those who show lethargy, who don't make their claim in time. So there's a time bar. There's a time limit also in making certain claims. So be careful about that. If there is any will in favor of some people for any estate, and if they think that they have to make any claim, they have to go to the court. So they should be mindful of the fact that there are time limits involved. Be careful. Do it immediately. Don't wait. Real estate or other property may need to be sold. As I've already mentioned, that although in the will the property is mentioned, but there are certain other cases which may require certain other acts by the executor to resolve it. This is here one of those. Real estate or other property may need to be sold to effect the correct distribution of assets pursuant to the will or merely to pay the debts. For example, there is one compact piece of land. Unless that land is monetized and that is liquidated, the liquidity is created, money is created, the distribution cannot take place. For example, there can be situations. In those cases, it may be sold. And then the amounts which have been received, they can be distributed. But here I may point out one thing more, which is although not mentioned here. For example, there is a property. it is subject to the law of inheritance. And a portion of it is the subject of will, which is called estate. Now, that property is a compact, for example, a house. It is a very valuable house. The man has died, the deceased is gone, but his wife is living there. In the civilized law and under the Islamic law also, you cannot expel the widow just to distribute the inheritance of the will, property of the will. You can distribute on paper. You can get the orders from the court that this stands distributed in this proportion. Now, these are the shares. Whenever this lady comfortably vacates this house, gets married at some other place, or she dies, when she vacates this house of her own will, at that time, these shares will stand and this property will stand with these shares for distribution. This is very important to note that just because of this reason, the property will not be sold and the woman cannot be expelled. There are many cases in the courts where people use this and they bring the case to the court. They expel the lady, the widow, and the widow comes to the court that I have been expelled because of this plea. Court can reverse the situation. Court has the authority. The widow cannot be expelled from the house of the deceased husband, even if that property has to be divided as inheritance or as estate under the will. They will wait till she makes her own arrangements. Estate taxes, gift taxes, or inheritance taxes must be considered, must be deducted like all other debts, like all other loans, mortgages, if the estate exceeds certain thresholds. If the tax is levied, if there is a gain tax, it is, for example, above 500,000. Up to 500,000 is considered to be a small estate, but if it is a big estate, which is subject to gain tax, gift tax, or other taxes, even gift, there are certain taxes if the value exceeds. Costs of administration, the executor is administrator, or the administrator is administering the estate. The costs of administration, including ordinary taxation, such as income tax on the interest which is being received till the property is distributed, and property taxation. The property tax is also there. The utility taxes may also be there. They have to be deducted from the assets, or when the assets are disposed of, from the liquidity, from the money which has been created before distribution by the executor of the will. It is his responsibility. Tomorrow, the court can take him to the law. The government can take him to the court. That why these taxes were not paid by the executor, he will be liable for that because he has stepped into the shoes of the testator. He is now liable. Other assets may simply need to be transferred from the deceased to his or her beneficiaries, such as life insurance. But there are certain other assets. Last time we had also discussed, for example, bank account. In the bank account, the deceased has nominated a person that will not be subject to distribution. Or there is life insurance in which there is a specific nominee intentionally. The deceased person has mentioned the nominee in the life insurance that I'm taking this life insurance, I'll pay for this as long as I'm living, but its beneficiary, I'm nominating my wife. So in that case, it will not require any distribution. But I have seen in many cases that people come and they fight against their mothers. My mother has got in life insurance of my father and she's not giving me share. He is not entitled to that share. It is her. It is widow's share. It is widow's property. Other assets may have pay on death or transfer of death. We already mentioned designations which avoids probate. If there is a transfer on death deed, then probate may not be required. If it is clear, it has already transferred, it has been already transferred to the beneficiary. Only the title will pass, and on the basis of death certificate, and on the basis of that transfer on death deed, they go to the concerned office, and the title will be changed. For that, probate is not required because the deceased person in his life had given, for example, just an example, the total property to someone as a whole, but to be transferred on death. So that is called transfer on death deed. But be careful that when you give the transfer on death deed, the property for the purposes of all other administrative and financial purposes, it transfers in the name of that person except the title. The title will pass after the death. But if you want to sell it, if you want to change it during your life, you cannot do it unless the person to whom you have made this transfer on death deed, he agrees and he comes to the office to transfer it. So you have to consider these points. There is an attestation clause of the will. The attestation clause of a will is where the witnesses to a will attest to certain facts concerning the making of the will by the testator and where they sign their names as witnesses. Now, this is usually the last paragraph or the last portion or the last column, or you can say the last segment of the corner in the document where the attestation clause appears, where the witnesses sign. So here, in many countries, it is required. The person who is witnessing, usually they make mistake. With the person who is signing, he just signs. But it is important to mention his full name as it appears on his identity or her identity. And then it's better to mention his identity number also, like national identity card number. And his date of signing should also be mentioned. So the point is that make it as clear as possible so that no doubt remains there and the person is identifiable. If the court needs after 20 years, after 100 years, they can call that person or they can call that call for that evidence or witness. I will not, I think I should not go into these details, but I am just exposing these certain points before you. We had started the discussion with the Mawali. Mawali comes from the word Wallah. Now, there are different meanings. All these meanings, depending upon the context, apply. But we are concerned here mostly with the term which is Mawali. So, what is Mawali? We have seen that word in the ayat that Allah subhanahu wa ta'ala says that I have appointed Mawali mimma taraka al-walidan, mimma taraka. As I said that he is representative of the state. He is Mawali mimma taraka. He is not Mawali of the person. The Quranic law was not made in the 21st century. It was made long ago. But look at the wording, the wisdom. Very subtle, very precise in meaning. Mawali, Jalna, Mawali, Mawali, Mimma Tarakal Walidain, Walidan, Wal Akrabun, and so on. So this is Mawali has so many meanings. Here another meaning will appear Mawla. I will, although it is not related to this subject, but I would like to mention it. that how people have misinterpreted this Mola, word Mola, but I'm not taking up today. Next time, Allah willing, I will try to discuss this Mawali and Mola, but I'm exposing it before you, that where we'll discuss it in the context of the legacy, we'll discuss it. So, Subhana Rabbika Rabbil Izzat Amma Yasifun wa Salamun alal Mursaleen walhamdulillahi Rabbil Alameen.
اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه. اللهم اهدنا فيمن هديت وعافنا فيمن عافيت وتولنا فيمن توليت وبارك اللهم لنا فيما أعطيت وقنا واصرف عنا شر ما قضيت. اللهم ادخلنا برحمتك في عبادك الصالحين. اللهم اخرجنا من ظلمات الجهل والوهم إلى نور العلم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا علما. اللهم اجعلنا ممن يستمعون القول فيتبعون أحسنه. اللهم اكفنا بحلالك عن حرامك وبطاعتك عن معصيتك وفضلك عن من سواك. اللهم بفضلك ورحمتك على كلمة الحق وانصر المسلم وانصر الإسلام وأعز المسلمين يا أكرم الأكرمين. Oh Allah, spread your mercy upon us, shower us with your blessings, increase our knowledge, grant us forgiveness, and reward us with the company of the prophets in the Firdaus al-A'la. Oh Allah, forgive our parents and all our friends and relatives who have passed away. Oh Allah, make their graves garden from heaven and grant them the Firdaus al-A'la. Oh Allah, we have many of our friends and relatives who are sick. Oh Allah, we have our son Ma'araj, our daughter Aisha Wani, and our grandson Isa. Oh Allah, grant to all of them full and speedy recovery. Oh Allah, guide our children, protect them, and make them righteous. Oh Allah, we seek from you all of the good, whether we know it or we don't. And we seek your refuge from all evil, whether we know it or we don't. Oh Allah, we have many of our brethren who live under oppression and injustice. Oh Allah, heal their trauma, protect their helpless, and grant them lasting peace and prosperity. Oh Allah, we ask with every name you have elected for yourself, that none of us leave this gathering, but his pains have been relieved, his worries have been removed, his debts have been paid, his weaknesses have been concealed, his sins have been forgiven, and his needs have been fulfilled. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. وآخر دعوانا أن الحمد لله رب العالمين والصلاة والسلام على خير المرسلين. اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه والسلام عليكم ورحمة الله وبركاته.